with people who aren't able to be here today. So VIP is celebrating its 40th year this year, 40 years of partnering low-income Philadelphians with volunteer attorneys where they would not be able to get legal assistance any other way. We focus on a lot of different areas, but estate planning is at a really unique position because it's a preserving income kind of practice for us. It helps our clients preserve their family wealth to pass it on to future generations. But it's also really important because VIP specializes in tangled title issues. And we do a lot of work and spend a lot of time and resources helping clients untangle title. A Pew Charitable Trust report came out recently documenting that over 10,000 properties in Philadelphia are tangled titles, and most of those are owned by people who are deceased. And so helping to prevent the tangled title issue is just as important as helping untangle title. So we are very grateful that you're here to discuss these issues today. And I am going to turn it over now to Jocelyn and Roxanne, but I'm happy to also pipe in with any other VIP related topics. So to get started, we'll talk about what these common life planning documents are. Jocelyn, do you want to begin?
Sure. Well, today we're going to address 4 common life planning documents: financial powers of attorney, healthcare powers of attorney, living wills, and wills. And we're going to go through some definitions first. You might have heard the phrase advanced healthcare directive. That's basically a synonym for a healthcare power of attorney and or a living will. So it's a document that might have both a healthcare power of attorney and a living will, or it might just be a healthcare power of attorney. And then powers of attorney in general, both financial and healthcare, they're documents that allow for a named agent to manage a principal's affairs when the principal can no longer do so independently. The agent is a fiduciary, so it must act in the best interest of the principal and not for the agent's own benefit. I want to just amend something to note that with respect to financial powers, they can be exercised by an agent even if the principal is able to also act. So just keep that in mind when counseling clients, that these financial powers are pretty powerful and could enable people to take steps with respect to the principal's financial interests, even if they're not incapacitated. So we can do the next slide. Execution of estate planning documents. Well, everyone wants to know whether or not, let me try, I don't know if that was me, let me turn that off. Everyone wants to know whether or not they need a notary or witnesses. And while the rules vary, with respect to a will, you absolutely need 2 disinterested witnesses. And your client's probably going to ask what that means, but an interested witness would be somebody who stands to benefit under the will, so rule them out. Usually family members, rule them out. They shouldn't be witnesses. A neighbor is okay. They have to be over 18. A will is valid without a notary, but and this is a huge but, there's always something attached to a will called a self-proving affidavit that must be notarized. So you really want to have a will and a self-proving affidavit. If you don't have one, if you don't have the self-proving affidavit, then when your client dies, the executor of their estate has to go into court and appear for a hearing for the witnesses to prove the will. So not convenient. It's much better to have a will signed with 2 disinterested witnesses and a notary. And I would give pushback if the client says, well, it's hard for me to find a notary. I would pretty much insist on getting a notary for a will, for the self-proving affidavit portion of it. Financial powers of attorney, you do need to notarize it. You don't need witnesses. Advanced healthcare directives, you need 2 disinterested witnesses. I would say overall, if you're creating all 3 of these types of documents for your client, just tell them 2 disinterested witnesses and a notary. And that's kind of a simple way of saying it. Next slide, please.
And I'll add in the age of COVID, there's been a lot of talk about remote notarization. I know due to the state of emergencies, at least in Pennsylvania and New Jersey, certain things were allowed to be notarized remotely. I think the estate planning bar, and Jocelyn chime in, have been treading very cautiously, but we get a lot of questions. Can we just sign our documents by Zoom? And the answer is no. Like, if you want to do it remotely, there's lots of protocols and procedures that have to be followed. The notary has to have a special process that she or he goes through, in addition to a special computer program. So it's much safer just to have your client either notarize them after he or she receives the documents, or wait until they can get into the office or VIP to have things notarized.
Right,
So,
and that's my understanding, is that in PA, the idea of remote notarization doesn't really work. And fortunately, with everything pretty much opening up, I would just go, have 2 neighbors witness and get a notary. And if, well, I was gonna say, if people know of an attorney, sometimes an attorney can act as a notary, if that's helpful. I mean, you guys are attorneys, so you may or may not be able to notarize under PA law.
And just an update from VIP's office, we've now reopened to having notary appointments in our office. So a client can always come into our office. You just need to schedule with whoever on staff you've been working with. So to find a convenient time, it would be one-on-one in the office, and we would provide the witnesses. We also have a few volunteer travel notaries who are willing to go to clients' homes, which is fantastic, so that the client doesn't have to leave their home. They could use some neighbors as witnesses, maybe do it out on the front porch or something like that. And then we have a whole list of other options for people to go to their local bank. TD Bank in particular will do free notarization for anyone, whether or not you have an account there. Jenkins Law Library has a setup for us. So we have a lot of different options available. Just, reach out to us and we can help you figure it out.
I think there's a specific question of who should be contacted specifically to arrange this at VIP. I think I just saw in the chat.
You can contact me. My name is Elias. If I haven't met you, Eli, I am the legal support coordinator. So I can help you with scheduling notary appointments. I'm also managing our estate planning program. So definitely reach out to me if you need anything like that.
Thank you. All right, so that sounds like that's the gold standard, would be to reach out to VIP for help with that. And Lindsay, did you want to go through some more tips before we move off this slide?
Sure. I think, we have templates, and so you have received a copy of our training manual, but when you get a case file from us, it will have links to Word documents that you can use as templates. And that includes a template letter you can send to the client about how important the execution process is. And then, as Eli said, he is the person to reach out to at VIP. I mean, you can reach out to any of us, but Eli is a good starting point. And then at the end of the case, what we're looking for is to see that you and the client have wrapped it up. There are fully executed documents, and you've sent a closing letter to the client to end your representation. And if you send that to your point person at VIP, whether it's me or Eli or whoever refers the case to you, we will help you close out the case. So and we like to keep copies of the client's executed documents in our file for the client. You're welcome to keep a copy in your file, and it's really important for the client to have the originals.
Okay. We can move on. Financial powers of attorney. So there are a lot of little things to know about financial powers. There are general financial powers and there are limited financial powers. The ones that we're talking about that you would prepare would be general financial powers, but you may have seen limited ones. If you've ever bought or sold a home, you might have had a power of attorney just to sign the deed or something of that nature. That would be an example of a limited power. With a general financial power of attorney, it's going to cover everything and authorize your principal's agent to exercise power over financial transactions for your principal. So that includes, paying bills, writing checks off their bank account, maybe selling their home. It's pretty broad once you take a look at all the provisions in it. And that's standard. That's what they normally look like. So counseling your client, I think you're going to want them to understand that it's broad and it gives someone a lot of power over their financial assets. So it should be someone they have faith in that they will execute or not execute the power in the best interests of the principal. One other thing I should point out before we change the slide is that financial powers and healthcare powers, they're good until the client dies. Once the client dies, they're not exercisable. That the will kind of picks up where they leave off. Okay, we can move on. Okay, some more background about financial powers is they will say there should be a recitation, and it's in your form, that the financial power is durable. All that means is that if your client becomes incapacitated, the financial power continues to be effective. It is not made ineffective as a result of your client's incapacity. There's a different thing called a springing financial power. That's a financial power that does not take effect immediately. It's a financial power that can only take effect if the agent is able to obtain a note from a doctor declaring the principal to be incapacitated. There are lots of reasons for using a springing power, but my understanding is that VIP doesn't use springing powers and is not going to provide forms for that. I'll tell you in my practice, some clients are very skittish about authorizing somebody to use their financial power unless they are incapacitated. That's how the springing power comes about. But in practice, it's often very difficult to get those doctor's notes, to get a physician to declare the person to be incapacitated. And then, if there's a reason that, if something is time sensitive and you're waiting to get a doctor's note, you can see the conflict there. And so that's probably, I'm guessing, VIP, this is why you don't like to use them. And I can say they are definitely cumbersome. I tend not to use springing powers, but if a client really presses me on it, I have the forms and I have used them.
And I can add, I know now in private practice, there are some reasons to use the springing, or we encounter them. I had a case recently where we had a springing document and it was a massive headache to get it, to make it effective and get the doctors on board and get the paperwork needed. So that's absolutely true. It causes delay. However, I think one way to counsel clients against it is to say, if you feel like you need the springing because you don't really trust the person, then maybe that isn't the right person for you to be naming. Because if you don't trust them now, what's going to make them more trustworthy in the future? And I do understand that some people might not have an alternate, but again, they being the agent are giving so much power. It's essential that the client truly trusts that person to do the right thing by them.
Right, so, and that's a really good discussion to have with the client. Who are you selecting? Another workaround that sometimes works for clients is by telling them, let's have you sign 2 originals. you keep both of them. I'll keep a photocopy in my file. And you don't necessarily have to give it to your agent until some point in the future, because after all, if your agent doesn't have a copy of it or even an original of it, they can't exercise it. Now, that could lead to a dilemma if your client becomes incapacitated and then can't give the power to their agent because they're incapacitated. But you can kind of navigate around that. Again, a financial power, it gets signed by the principal, but there's a page at the very end of it that is a signature page for the agent to sign. And you hope the way it's supposed to work as a financial institution is supposed to make sure that that it's fully signed by both the principal and the agent. So the agent will have to sign it at some point to make it effective. We can go on because some of this is covered on the next slide. Right, so the agent is a fiduciary again. So the agent, it's nice to have a chance to talk to the agent also. And oftentimes the agent is going to be a spouse or descendants, the kids, but sometimes, people have more ancillary relatives who they want to put in there. But it's nice to, touch base with the agent and let them know you're a fiduciary. You have to act in the best interest of your client, your principal, meaning your client. Cannot commingle, do not withdraw the funds from the principal's account and put it in your own account because you think it's more convenient. Don't do that. You have to keep good records. And if you're handy with the spreadsheet, every time money comes out of the principal's account, you need to document, why and keep receipts and so on and so forth. You might not have an opportunity to meet an agent though. Okay, next topic is joint versus successor. I like to offer the opportunity to use joint agents for financial powers because now you have two people kind of keeping each other honest. It's more cumbersome because now if you have joint agents, you need 2 signatures for everything. And let's see, VIP, do you have an opinion or Roxanne, do you have an opinion on joint versus successor?
So I think the cumbersome piece with the joint agents is can be an issue. The clients, the agents really have to understand they have to work in tandem. We will draft documents where you can put in language that they can act joint but separately so they can each do their own thing. However, I think that's even trickier because then the agents really have to communicate and trust each other. So I think for ease and understanding, it's easier to have one and then an alternate or a backup. So but it's again, us as counselors, as attorneys, as counselors, and really helping our clients understand the options and then make the best choice for her and her family.
Right, and again, just coming back to my experiences, my clients, they love the co-agents. They love it because they'll say, I've got 2 kids, one person's, responsible, the other's not responsible. I could put the responsible person in, but I want the other one to sort of back them up, or I don't want to make someone feel left out. We kind of go through all those discussions. Mm-hmm. But anyway, we can go on. You get the gist. Okay, so we've kind of covered this. There's the form that VIP is going to give you is going to have all the right statutory notice and acknowledgements, and the whole thing needs to be signed. All the signature lines need to be filled out and it needs to be notarized. Good point. Second to last bullet point down here is the client must have an unexpired government issued ID to present to the notary, because a notary needs to attest that they either know the person personally or they've seen identification. So that's a good point for the notary.
We didn't used to have that bullet point in, and our notary at VIP, Joe, asked us to put that into our presentation because it does come up often enough that it's worth talking about with your client.
Right. And so I think we've covered just about everything, and the form that you've included is the right form. This has to do with, this is for the agent. Oh, no, this is other stuff. The acknowledgement does not have to be signed during the execution. The acknowledgement does not have to be notarized. This is the agent's acknowledgement you're talking about. The acknowledgement doesn't have to be returned to the attorney. It just needs to be signed by the agent before the agent uses the document. Yes, that's all true. But you have your last, I'm skipping to the bottom bullet over here. The acknowledgement should be signed in front of the principal to prevent fraud. Again, if you go back one thing, again, the purpose of this acknowledgement is just to give notice to your agent that he or she is acting in a fiduciary capacity. And it's also a sample of the agent's signature. All right, we can move on to healthcare powers.
I guess before we move on, does anybody in the audience have a specific question or general questions about financial powers?
We do have a question in the chat from someone who works with a lot of undocumented individuals and wanted to know if there are any rules or statutes regarding the immigration status of people seeking to have a POA executed in Pennsylvania. And I don't believe so. I mean,
We're not.
The government issued ID to get in front of a notary is important. And the financial power of attorney is the only one that absolutely requires notarization.
You know where that information is in the notary rules. Because Pennsylvania is one of the few states that makes people take an exam. And I was talking to someone in our office who just did it. And Jocelyn, you touched on this. So to sign a document, the notary needs to see a photo ID, a valid photo ID, or could someone, isn't there another rule, like someone can tell the notary that this individual is who she says she is, that maybe someone without ID could rely on? I don't know.
An attorney can do that if the attorney is willing to have something notarized in Pennsylvania saying, I know who this person is. And there's also an exception if the person happens to know a notary personally. So if your friend up the street is a notary and they know that you are who you say they are, then they can notarize it without photo ID. But otherwise, in the notary log, the notary has to log how they identified the person.
Okay.
Well, sorry, I'm the person who asked the question. Hi. And it sounds like, I mean, you can have your Mexican passport. That's a government issued ID. Right. And those are typically bilingual. So, I mean, they typically are trilingual, like they usually have like at least the English and Spanish of like, you know, name, nombre. So it sounds like as long as, you know, if you have that would be sufficient. I was just wondering, like in Pennsylvania, whether there's something that's like, oh, this person, you know, in order to have a financial power of attorney, they need to have some sort of immigration status, but that doesn't seem to be the issue.
No.
Okay.
There's certainly nothing in the financial power of attorney statute that says anything like that.
Awesome. Thank you.
And I think, you know, there's like there could be notary police, and of course they are answerable to a higher body, but I think if the notary is comfortable with how that person has verified their identity, more often than not, it's probably not going to be an issue. You know, you can still get the will probated. Maybe if there's a huge will contest and it comes down to the notary, you know, I would be surprised if that were true, but I could be wrong.
There's a couple of other comments in the chat that seem to go along with where we have ended this discussion, if anybody wants to check it out.
All right, healthcare powers of attorney. Every time I look at the word healthcare, I struggle with whether it should be one or two words, and I think it can be both. I like one word better, just saying. All right, so healthcare powers of attorney. Again, we have this principal-agent relationship. And the difference with a healthcare document, when you put your lawyer hat on and not how this might work in real life, is that it's only supposed to kick in when the principal can't make decisions for herself anymore. The doctor, the medical team is always supposed to be asking the patient what she wants done, what kind of treatments she wants done, because in our Western world, we love the idea of autonomy. We want people to take control of their own decisions, their own futures, and really continue with that as long as possible. So the healthcare power is really supposed to kick in when that person can't make decisions or might need to be supported more fully in decision making. So to that end, again, you want someone who's trustworthy. They understand the client's values and beliefs, because this person is going to make treatment decisions, which could include end-of-life treatment decisions, but also hiring and firing medical personnel, and depending on how the document's written, admission to a nursing facility, and this whole continuum of long-term care, how that's going to work together. And you can also name joint or co-agents. Again, they have to act jointly. So the prior document with the financial power of attorney, technically, you could put in language so that the joint agents could act separately. I think that's a horrible idea to do in a financial document, because you can imagine worst case scenario where you've got two joint agents who can act separately, and mom is on a breathing machine and one's saying unplug her and the other one's saying keep her alive. It just creates I think a poor outcome. So you want people who will work together and hopefully agree. And then if they're named jointly, the medical team in theory hopefully would wait them out until they can agree on a decision. But for here, it's also helpful to name, for that reason, an agent and an alternate. What we see sometimes with families is one kid's in charge of the money, another kid's in charge of healthcare. So they each have a little piece of parents' destiny and future, and some skin in the game when it comes to the parents in particular. What is worth, and I can't remember, actually, can you advance the slide? If not, I'll make the comment because I can't remember if it's on the next slide or not. So what I will say, and forgive me because we might cover this later, I'm blanking on whether it's in here or not, but with healthcare powers, and also to an extent with the financial powers, the decision-making standard is substituted judgment. That's where you start. And this is particularly important for healthcare, meaning, the end of life situation is probably the best example, but it's supposed to trickle throughout the whole document and throughout the agent's role. But you're supposed to think about, what would mom want to have done? If mom is terminally ill with, I don't know, at the end stage of an ALS or MS, and all of a sudden she's diagnosed with breast cancer, would mom want aggressive end-of-life treatment? You think about, have you had conversations with mom about what she would want? Were you watching a TV show or a movie where something like this came up? What did mom say? And you have to put yourself in mom's shoes and think about what mom would have wanted done. You may want mom to go through chemo or aggressive therapy for breast cancer, but that's not the decision you should be making. You should be deciding based upon what you know about mom. Unfortunately, not everybody has that kind of clear guidance. So, in the end, the great default is the best interest. What's in the best interest of the individual in making those decisions? But it should never be what you think is best individually, but overall, what is in the best interest. So I digress now, back to drafting and execution. So again, we have the co-agents, and that is usually, what the primary conversation. So in thinking about who they're going to name, again, it's someone they trust, but to the end of the substituted judgment, you want to make sure your client has also discussed with the agents what their healthcare goals are, what they foresee for themselves in the future, what kind of quality of life they want. And I work with seniors, so maybe this is more on the forefront for me and what I do, but even if it's a younger person, that doesn't mean they can't start having those conversations early, because their agents really should be doing what they would want to have done. And the healthcare documents are extensive. They cover all areas of healthcare. They also include a HIPAA waiver, which really shouldn't be removed, because it's hard to make healthcare decisions if you can't access all of the protected health information. We have reviewed the powers with the client, and the client can strike any. It's probably neater and cleaner to just delete it out of the document, but either way, if there's something someone doesn't want, it certainly can be removed. And again, we have the government ID. We want it in front of a notary. Notary is gold standard. We really, truly want everything notarized. However, it's worth, knowing that a healthcare power of attorney can be executed without a notary. And I have a hard time imagining that a healthcare team in a hospital is gonna be feeling for the notary, raised notary seal when they have to make a split decision. So that's probably fine. So living wills, could advance the slide. So living wills are a more narrow version of healthcare guidance and decision-making. So historically, we think about living wills as a checklist, 8 or 9 treatment preferences. I do or do not want my heart restarted. I do or do not want a feeding tube, and so on. I think in modern drafting, we're starting to see more treatment preferences about what someone really wants when they're end stage or terminally ill. That also includes permanent unconsciousness or even a persistent vegetative state. That's when this directive should really kick in. The statement should be more appropriate for clients who do not want any life-sustaining treatment. And that's important to note, just because if someone's rushed to the ER, to the emergency room, the medical team's directive is to treat. That's what their job is. They're gonna do what they need to do to keep an individual alive more often than not. So if someone doesn't want the medical default, it's important to have those wishes stated. In addition, with healthcare, the healthcare power, we were talking about how, what would mom have wanted? A living will really is, to use a legal standard, clear and convincing evidence of what that person would have wanted. It's indisputable if it's executed and timely that mom would not have wanted aggressive treatment, or mom would not have wanted a feeding tube. So the living will would also serve that purpose. Pennsylvania end stage medical condition. It's been a while now, but they did revise a lot, maybe 10 years ago, to start using sort of terminal end stage medical condition. So it's incurable and irreversible. That in the opinion of the attending physician. So sometimes when we think about these documents, and some may still be drafted this way, it used to be upon agreement of 2 physicians that someone was terminal. So this specific language is popping out the need of 2 doctors to agree, and just saying the attending physician. So that could be someone's primary care doc who's involved with care, or even someone in an emergency situation or in a hospital. So in a reasonable degree of medical certainty results in death despite the introduction of continued medical treatment. And the other reason this language was introduced was to encompass progressive chronic conditions, but eventually fatal, of unknown duration. So, for lawyers, I still think that's kind of nebulous, but one could argue that Alzheimer's is an end stage medical condition. While you might not die specifically of it, it might be failure to eat or failure to thrive. It's ultimately something that's fatal. And if the physician will not certify as end stage, it's not to prevent treatment if someone would benefit from the treatment, including palliative care. And the treatment will not just prolong the process of dying. So if there's some medical benefit to introducing a specific treatment, the doctors are still supposed to do that. And we talked about the only 1 physician being needed. So living wills in drafting and execution discuss the client's preferences, determine whether they want a checklist or the statement. I think some more often than not, in private practice where it's been a different client base, I would say people for the most part are pretty confident they don't want aggressive treatment. There are exceptions. And I found that people and clients have thought through this a lot already. And maybe that's what spurred them on in part to come do their estate planning with an attorney. However, in my public interest practice, my experience is a little different. I don't know that my clients had the opportunities and experiences to really think through what their end of life preferences were. So that can make it hard because, I'm not a physician, I'm not a medical person. How do I counsel someone on what it might be like to withdraw life-sustaining treatment, or maybe not even introduce it? So if someone is really unclear about what they want, it's worth recommending they do talk to a medical provider about what that means, what end of life decision-making means, aggressive treatment versus not. But if
And,
they're
and
ready,
just to jump in there, I
yeah,
think if someone hasn't had an opportunity to really think this through, you could go through that checklist format and go item by item. Well, how do you feel about this? How do you feel about, withholding antibiotics? How do you feel about a feeding tube? How do you feel about withdrawing hydration? I can tell you, my clients tend to like the statement format, but they all say the same thing, just they want treatment for pain, but they want you to pull the plug if there's no hope of survival.
and that's how, it's helpful to know. And everybody, then they can have the outlier. So you don't want someone signing this if they really haven't really thought through it. So you can sign in, so for execution, sign and date in front of 2 witnesses and a notary if possible. We need the photo ID, but you can get away, of course, without having the notary. But again, the main thing with these documents is communication and dissemination. Loved ones and family members need to be on the same page about what someone's treatment preferences are, especially if they're older, what the values are, so that in the end, and it's been a while, but in my prior life, I did work with medical teams as a baby attorney about advanced directives and how they were implemented. In my experience then, and it may have changed because time has passed, but if a family is over someone's deathbed fighting about whether or not to withdraw life-sustaining treatment, even if someone is the agent under power of attorney for healthcare, but there's a big family fight, they're probably going to bring that to the ethics committee at a hospital. I don't think they're just going to default and follow what the agent says, because in the end, I think the hospital's worried about liability. So the hospital's going to do what they can to make sure everyone's in agreement. So while having this document in place is ideal, communication, dissemination, getting everybody on board before there's a crisis is really important. And one thing not in this presentation, and maybe we should add it, unless it's been added again, I apologize, is that in Pennsylvania and in many other states, there's something called a physician's order for life-sustaining treatment. This is not a legal document. It's not prepared by attorneys. It's something that clients would complete with their physician. But essentially what that does is distill down a lot of these very specific treatment preferences I do or do not want, and transfers them into what's understood as a medical order. So you have something called we are probably familiar with DNR, do not resuscitate, but the Pulse takes the DNR a step further and talks about, what I'm remembering is tube feeding, other different types of aggressive treatments. And when a medical team sees one of those signed, they can travel, they're portable, they can travel with the client. They're much more likely to follow it because it's in their language. So it can't hurt to let clients know that that document also exists.
I will say the one other thing that I counsel clients on with the living will in particular is that if they have chosen someone as their agent, it's often helpful for that agent to have the living will as a written document to let them off the hook a little bit, because it's hard to make those decisions when a family member is in, or a loved one is in end stage medical conditions. And it's helpful to have written down for that agent what the person would have wanted. So even if someone is choosing a healthcare agent, I like to encourage them to also do a living will. All of our clients, we have, a brief discussion with them about which documents they want. But as a practitioner, the person who is drafting the documents has a responsibility to discuss those preferences with the client, talk through which documents are appropriate and which aren't. And so some of that counseling piece can be really helpful to narrow down which documents are appropriate. And the template we have is sort of a combined healthcare power of attorney and living will. There's 3 sections, and there's a living will section and an agent section. But they can be done separate. You don't have to use our template, or you can break our template apart based on what the client wants. But it's just worth knowing that one of the counseling techniques I use is to let them know that it is it's helpful to the agent to have more specifics written down, I think.
No, I think that's a really important point, because making that decision for a loved one or a family member is huge, and it sort of relieves some of the burden and the guilt for the agent if it's very clear what the preference is.
Does anybody have any other questions before we move on to simple wills? We underline the simple, hopefully.
Which are not really that simple when you get into it. It's just very hard to make a will very simple because there are a lot of things you have to think about. So you can proceed. Well, VIP assists clients with simple wills, not really doing trusts, and the client has minimal assets. So we're only going to go over the basics today. Let's talk about some elements. First of all, an executor, that's like the manager of the person's estate. And the executor's job is to collect the assets and distribute them pursuant to the terms of the will. An executor, just like any other agent, should be somebody who's trustworthy, who the client trusts. Oftentimes it's a child. An executor and an alternate should be named. Now, in estate administration, when somebody dies, the period of administration is, 1 or 2 years, approximately. There's no set time. So this person is only going to be in this role for a couple of years, but they're going to have the responsibility for collecting and distributing assets. So that's important that you trust them and that they're a responsible person. Co-executors, VIP does not like co-executors. Pros and cons. Oftentimes the client's going to want to name the 2 kids as a co-executors. And if they get along, great. If they don't, major friction, and that could be a problem. So, I definitely, in the area of an executor, I think naming a single executor is definitely a lot easier for processing the estate. And in a certain sense, because if you name child A, but child A and B are both beneficiaries, child B is going to watch very carefully that child A is acting properly. So the need to have co's is perhaps not as urgent as in other areas. So, so an executor and an alternate is probably going to be where you want to end up. Okay, next slide. Okay, so intake. You need to get some information from your client. Who do they want to benefit? What are their names? If it's a common name, maybe, take some additional notes down. I don't normally put, well, actually, I've seen it in both ways. I've seen some wills drafting styles where you would say, my daughter, say her name, comma, of, city and state, just for clarification of who this person is. And if the person is a minor, okay, so that's an important issue. If somebody is a minor, property can't just be distributed to a minor. So it has to be put into an UTMA account. Your will should address that. Your will should say something like, I want to distribute it to an UTMA account and name who the account custodian is for that UTMA account. You could name a guardian under the terms of your will to act on behalf of the minors. I know in my agreement, my trust agreements in particular, not so much wills, we say, even if the person is not quite an adult, you can make a distribution to that person. Not so for bank accounts, because you really do need an adult to open a bank account. But if it was just tangible personal property, your executor could make a distribution to somebody who's not an adult. It just depends on what that property is. Same disabled beneficiaries, that's another important thing to understand when you're preparing a will. If that beneficiary is receiving government assistance, that's something you need to know, because you might need a special needs trust, and that's a little bit beyond scope, but you should want to let VIP know if you find that there's somebody who's on government aid, who's a beneficiary, who's disabled. Charitable bequests, some clients want to leave to charity. The way to identify a charity is you need to look up the formal name of the charity and where it's located. So if it's American Cancer Society, you could say that, of, you know, wherever its main office is. Usually I'll look it up on their website and see if I can figure out what their actual name is. Okay, you can keep rolling. Contingent beneficiaries. This is basic will drafting 101. If your named beneficiary predeceases, who should it pass to? Should it pass to, you know, my issue then living per stirpes? That means, you know, if you have 2 kids, it goes to the 2 kids in equal shares. But if one child is predeceased but dies being survived by his own kids, it would, the grandkids would take the share of the deceased child. That's an easy way to, you know, plan for alternates. Sometimes people have specific bequests. I want to leave this piece of jewelry, my favorite watch, to my nephew, so-and-so, but if he predeceases me, then X. Just ask the question. Okay, here's another topic that's not so simple, which is spouses. A lot of times people will leave their estate to their spouses. A spouse can't be disinherited unless you have a valid prenuptial agreement. So that's a good thing to ask the clients. Do you have a prenuptial agreement? If the answer is no, then a spouse can do something called elect against the will. So if your client says to you, you know, I don't get along with my spouse, I kind of want to, maybe I'll give my spouse, you know, $1,000. But I'm giving the rest of my estate to my kids from a prior marriage. Well, electing against the will is something that the surviving spouse can do and get, it ensures that a surviving spouse gets a portion, I think it's a third in Pennsylvania, of the decedent's probate assets. So if they had $9,000 of assets and they only gave $1,000 to their spouse, the spouse can get the $3,000. That's just something to be aware of if your client says, I want to cut out my spouse. Okay, next. Yes.
Also with VIP clients, due to the limited access of resources, many may have been separated for many, many years and consider themselves divorced, but they've never been legally divorced. So spouse who took off a long time ago could always resurface and try to make a claim against the will.
And that's a good point. If they say they're divorced, you might want to say, do you have a divorce decree? Did you ever get a court order? Good point. Client's property. You should understand the nature of the client's property and its approximate value. You don't have to know precisely, just ballpark. And in part, that's to understand what a spouse's elective share might be, but also just to make sure you've got a listing of everything. So when you get to the, you know, how you divvy up the assets, if you're going to use a residuary clause, you need to know what the everything else is. And we'll go to the next page. That'll be a little bit more clear what I'm talking about if we go to the next slide. Well, this slide is about real property ownership. So let's talk about that for a minute, because this, again, is an issue. You need to see a copy of the deed. That might be hard to get a copy of the deed. If you have an address, you might be able, I don't know if VIP has these resources where you can look up the deed online and get a copy of it. But I know I know we've been able to get copies of the deed for real property online, but that's, you want to see who owns what and what the title looks like. So if the title of the real property says it's in the name of your client, good. If there's joint ownership, that's where it gets a little bit complicated. So you have to understand if there's rights of survivorship, or if it's a tenancy in common, if you have co-owners. You'll know if there are rights of survivorship because usually in the first paragraph, it'll indicate that way. So it might say something like, John and Jane jointly with rights of survivorship. It might just say that, or it might say John and Jane, husband and wife. That is a survivorship provision, or it might say tenancy by the entirety. All of those things mean rights of survivorship. So if so then your next question is this person, are any of the co-owners deceased now? And if a co-owner is deceased, that will affect your analysis. If you have somebody who owns, okay, I see a message from Lindsay, your VIP case file will come with a copy of the client's deed. Good. If your client owns something and it's not with a co-tenant by with the right of survivorship, that means it's a tenancy in common. So your client owns a rateable share of the whole. So if there are two tenants, your client can give away basically, your client's tenancy in common interest. This is a whole, I don't want to get too off with real property and how that works when a tenancy in common is inherited. I think that's a little bit off course and not exactly what I do, but I think you have to partition it, foreclose it, or buy out the co-owner. It's a bit of a thing. But for purposes of drafting the will, if your client is a co-owner as a tenant in common, your client absolutely can bequeath, devise that tenancy in common, and that's no problem. But if there's a survivorship provision, then that property passes by operation of law, and if there are survivors, and is not controlled by the will. So that's why it's important to look at the deed and understand how the real property is owned. I'd say some of that also applies for joint bank accounts. That's something you ought to take a look at. If a client has a significant bank account or a brokerage account, you look at the bank statement and see how it's titled. Okay, let's move on. So usually you'll see, and I took a look at the will form that is provided by VIP, and it's got pretty much all these elements in it. You will see something that says, I bequeath. Sometimes the client might have specific items of tangible personal property or a cash sum that the client wants to give to a particular person. So you'll have a, bequest of a sum or bequest of specific property to a specific person. And in that situation, you should definitely ask the client, who's your alternate if this person dies before you. The client does not have to make specific gifts. You can just have everything pass, whatever I have passes under the residuary clause. Another option, and the form for this is included with your materials, is that a client can make a tangible personal property memorandum that is kept with the will. So then you would have a tangibles clause in the will that says something to the effect of, I give whatever I've provided for in this separate written memorandum, but if I haven't written a memorandum or you can't find it within 6 months, then I give all of my tangible personal property to X or Y. The nice thing about a tangible personal property memorandum is it's kind of a listing of specific property and to whom it's bequeathed. And it doesn't need to be notarized or witnessed. Your client can just sign it and date it. So it's a nice handy thing to have if your client's got a lot of trinkets or whatever that they want to give away to specific people, you don't necessarily have to list it in the will. You can use this separate written memorandum and it will be honored.
And clients can update that more
Yes,
easily.
and they can update it. They can update the tangible personal property memorandum. Oh, and I see we're coming up on one. So why don't we keep moving? Because we're going to get to the residuary clause. So the other thing you should have in a will is the residue clause. Residue covers the everything else that you haven't already given away under the specific bequest clause. And it's whatever's left over is going to who. So it's whatever's not covered previously in the will. It's going to pass to whoever they name. You should definitely look at what they own to see what that amounts to and have that discussion with the client. And there's a residue clause in the forms. Next.
Okay, I think since we are up against 1 o'clock, I think we should stop here and just see if anybody else has any other questions that we want to get to. There's a few more slides in the materials, but please feel free to reach out to me if you have any questions about that material. And I'm not seeing any other questions in the chat.
I just had a quick question. Have the forms, the power of attorney forms, ever been translated in Spanish by VIP?
We do have we have the will, the financial power of attorney, and the healthcare translated into Spanish. Yes.
Okay.
I don't know that we have all of our letters, although we've been working on getting all of those letters translated.
Okay. Should I just email you to?
Yep, absolutely. Thank you so much, Roxanne and Jocelyn. We really appreciate the time that you took to present to us today. And thank you all for attending. We hope that with the, in exchange for this wonderful content and for the CLE credit that you will get for attending today, that you would consider taking a VIP case. I shared the case list with you, and I will share it again when I send the CLE credit form. I do see that there are a few people on today who have like iPhone as their name, and so I won't be exactly sure who to send it to. So if you do not get an email from me this afternoon, please feel free to email me to request your CLE credit form, and I will put my email. Oops, I went right on through it. There's my email and my phone number if you want to get a hold of me. So I will send out those follow-up emails with the evaluation form and the CLE form. The CLE form is what you need to send back. And then again, just hitting home that VIP has resources to help you. Our staff is there 100% of the time to help clients and their volunteer attorneys. So we don't do direct services. We're here to support our volunteers. We have the templates, we have our training manual, we have volunteer interpreters if you're willing to take a case for a client who does not speak the same primary language that you do. We have mentors, and we actually have a case that needs a mentor. If any of you on this call would be interested in mentoring for a case, let me know. And we will look forward to working with you. I see we have one more chat question. No CLE code. You just need to complete the form that I'll send you and send it back to me. And if any of you are interested, we have our annual awards night coming up on October 12th at 6:30. Please register for it. We like to celebrate our volunteers. It's actually the highlight of the year, in my opinion, celebrating our volunteers and thanking you all. We also have a Welcome to Philadelphia VIP session coming up on October 28th. If anybody is not familiar with VIP or wants to know more about who we are and what we do, that will be October 28th at noon, and you can sign up for that on our website. So I am going to end the recording now, and I am going to say,